very convoluted and confused.
Sure.
Let's start off with what we had before November of 2010. ARS 13-3405 is our statute that basically says you may not possess, use, produce, transport, or sell marijuana, period. In November of 2010, voters approved by 4,300, and honestly, it doesn't matter if it was by 1 or by a million.
Right.
Voters approved an initiative, and I'm going to refer to it as Arizona's Medical Marijuana Act, that said, despite our state law that says you can't do these things, if you follow a state program and you're a qualified patient,
Sure.
or you're a caregiver, or you are a licensed dispensary or a licensed cultivation site, you can be authorized by the state to possess, use, grow, distribute, or sell marijuana. Okay. At the same time, we have the Federal Controlled Substances Act, which says, consistent with 13-3405, you can't do any of those things.
That marijuana has no medical use, right?
Well, no. And I want to be very clear too.
Right? That's part of the act.
Yeah, that's part of it. But I want to be clear too that there are two distinct parts to this. One is what I'm focused on right now, but I'll give you a complete answer, and I'll also talk about the scheduling. Sure. Because right now, as a consequence of marijuana being a Schedule I drug,
Sure.
there's a determination by the federal government that there's no medicinal purpose, yada, yada, yada. But that as a consequence of that, you can't possess, use, grow, cultivate, all that other stuff with marijuana. Because there's a federal law that prohibits it, the state cannot authorize the same conduct. Because
but they did. I have a card that says I can cultivate.
Right.
It's given me by the state of Arizona.
And if the state of Arizona gave you a license to rob a bank,
but they wouldn't. They wouldn't do that.
I don't think they've ever given a card.
You understand? They never did.
Let him answer.
We can have a very respectful. We can have a very respectful difference of opinion here. But I'm trying to show you the analysis and the difference between what I'm seeking from a legal ruling standpoint and the policy differences.
Right.
Under the Supremacy Clause of the Federal Constitution, you've got an act passed by Congress. It trumps a state constitution, any state law, any local ordinances or statutes. That's the system of government that we have. What I have said is, look, unless and until a court says Arizona's Medical Marijuana Act can be implemented, even when we've had other courts in other states say that there is preemption, and you can't authorize conduct that the federal government has legitimately said you can't do, they can't coexist. You're asking people to do something that the federal government prohibits but the state authorizes. That's the nature of preemption. If that's true, then I'm left with state law. State law still then holds because those exemptions don't count anymore. You know, federal law basically knocked out those exemptions, and so I have ARS 13-3405 to enforce.